departed from Juba on the 19th day of September 2018 at 3:58 p.m. on a flight KQ 353 to Nairobi and arrived at the Jomo Kenyatta International Airport at 5:45 p.m. The court was given the benefit of the passenger manifest, and it indicated that the deceased on the material debt used a passport number CE034168 and her ticket number was 706200860 She sat on seat number 28A. In addition to that evidence, the court had the benefit of the evidence of PW18, Teddy Mugambi Kiaria, who is the head of surveillance at the Kenya Airport Authority. Her testimony to the court was that she received a request from the Director of Criminal Investigations to provide CCTV footage of the movements of the deceased person on the material debt. She then went and made an observation on the same in the company of the investigating officer, and it was revealed that when the deceased alighted from the flight, it was at 17:38:19 hours. And by 17:41 hours, she was at the immigration desk. She went to the baggage hall, picked her luggage, and exited towards the international airport stage by 17:51:10 hours. The evidence of Okech Otieno John, who testified as prosecution witness number 6, is to the effect that he operates a taxi. He received a request from the deceased person. He responded positively, and that was about 6 p.m. He picked her up from the stage using his taxi registration number KCQ 399C Nissan Wing Road and dropped at the destination, which was Dennis Pritt Road, Kitale Lane. As is expected, he was paid his dues and left. The witness indicated that before they go to Dennis Pritt, the deceased called a border rider whom she met at Nyayo Stadium, according to his evidence, and handed over an envelope to him. According to him, their time of arrival at Ramura Gardens was about 7 p.m. And as I've already said, he was paid and left. The evidence of the prosecution protected witness number 3A is the guard at Ramura Gardens. And his evidence is that when the deceased arrived at Ramura Gardens, she picked her house keys and her laundry, which had been left at the sentry house by the person who was working in her house in the day, and they were left with the day guard. It is his evidence then after she picked those items, she proceeded to her apartment, which was apartment number A8. It is the prosecution case. Thereafter, the deceased was visited by 4 people on that night. According to that protected witness, PW3A, the first visitor whom we had the benefit to allow to have access to the deceased house arrived at about 8 p.m. He arrived in a taxi, and he was a male person. He was dressed in a white kanzu, a gray jacket, and a maroon cape. Upon being asked to identify himself, he identified himself as Haron, and gave out an identity card in the name of Dominic Becerra Haron. His request was to be allowed to go to the deceased house. The guards' evidence is that they called the deceased to seek for authority to allow the visitor, or otherwise. They were given authority, they allowed the visitor, and the visitor proceeded to the deceased house. The next person who was in the deceased house on the material night is PW7, Lee Owen. His evidence is that he arrived in the deceased house at about 9:15 p.m. He had gone to the deceased house, having met the deceased earlier, having had a discussion with her, and he was going to pick documents from the deceased. Owen testified that when he got to the deceased house, he found the deceased in the company of two male persons. One was Mr. Waridi, a neighbor of the deceased person, and an occupant of apartment number A9. A neighbor and an occupant of apartment A9. The second person whom Owen found in the deceased house was introduced to him as Joe, a security officer with Interpol and Office of the President. And so, as I've indicated, the evidence reveals 4 people visited the deceased on the material night. At this point, we are at 3 persons: Mr. Waridi, a neighbor, Mr. Owen, PW7, and one who was introduced as Joe and who was cleared at the main gate as Dominic Becerra Haron. Anton Kariuki Kaka, PW16, testified that he visited the deceased person, on the material night. His evidence is that he did not gain access to the deceased house as the deceased opted to meet him at the parking area. And the reason why the deceased opted to meet him at the parking area is because the deceased informed him that he was having guests in her house who included a guy from State House. And so their conversation was held and ended at the parking area. It was the evidence of Mr. Owen, PW7. There was a general talk as they sat in the deceased house. 3 gentlemen and the deceased. And that the first person who left the deceased house was the neighbor, Mr. Warid. It is the evidence of Owen that he was the next person to leave the deceased house. And it is further evidence of Owen that by the time he left the house at about 10:40 p.m., he left the deceased in the company of the visitor who had been introduced as Joe. It is the evidence of PW3A, the protected witness, the guard at Ramuria Gardens, that the last person to leave the deceased house was Dominic Becerra Haron, who left at hours 23:21. And that after that visitor left, no one else went to the deceased house. The evidence of PW10, the brother of the deceased, George Kimani, is to the effect that the deceased who had traveled from Juba on 19th of September 2018 was scheduled to travel to Dubai the following day. But she had indicated to her mother that she would see her before she leaves. And so the family tried to reach her because she did not visit the mother. And so the brother's evidence is that since her calls were not being answered, he chose to go and check on her at her residence. He went to her house in the company of his girlfriend. And when they got to the deceased house, they couldn't access the house because the door was locked. And so they sought help from the caretaker at Ramuria Gardens. The caretaker testified as PW13, one by the name of Regan Irungu Buruku. It was his evidence that when the deceased brother sought for assistance to access the deceased house, he instructed the gardener, one by the name Stephen Wanjoy, who testified as prosecution witness number 14, to get a ladder, as they had discovered that the window and or door to the balcony was not completely closed. So the gardener got the ladder, got to the balcony, and managed to access the house. It was the evidence of the gardener that when he got into the house, he found the television was on, water was running in the bathroom, but there was no one in the sitting room or in the bedroom. He proceeded to the bathroom and found the deceased's body in the bathtub. There was a mobile phone next to it, and there was water running over the body from the telephone shower. It was his evidence, as of course would be expected. He went into shock and immediately notified the caretaker and the brother of the deceased, whom he had left outside the house. He then requested the door be broken so that they could gain access. That was done, and subsequently the matter was reported to the police. Among the officers who visited the scene is Corporal Jennifer Sirwa, number 75179, who testified as prosecution witness number 2. Her evidence was simple. She processed the scene, and she took a total of 50 photographs of the scene. Those photographs were taken from various points, indicating various areas and items, which included but not limited to the general view of Ramuria Gardens apartments, closer view of Block A, where the apartment of the deceased was. There was evidence that there was a yellow bag whose contents were not disclosed, hanging on the door. Was a photograph to that effect. The sitting room, the bedroom, the personal effects were photographed. The body, and those photographs were produced in this court as evidence. After the photographs and the scene was processed, the deceased body was moved to Chiromo mortuary. Of course, as is expected, investigations commenced. And it revealed that several people had visited the deceased on that night. Those people became of interest to the investigators. And as that was going on, Walidi, the neighbor of the deceased person, is said to have notified the family members that he had been and was in the deceased house the night before. And he mentioned, and so did Owen, that he too was in the house, but they were in the company of one Joe. It is in evidence that the deceased brother, Kimani, knew of a person by the name of Joe, and he sought to establish from Owen, through a photograph given to him, whether that was the person who was in the deceased house, and Owen's answer was in the affirmative. Mr. Kimani testified that he knew Joe, as they were in college together at Kenya Polytechnic as far back as 2012. And that he knew that Joe was known to the sister, the deceased, and he knew that Joe had a fiancé who was in the media industry, and so he approached Joe for assistance to have the death publicized. It is the evidence of Kimani that when he approached Joe for assistance, Joe told him that he would get no assistance from the media, but opted to assist through his private company to deal with the matter. The investigations advanced. It was discovered that the first accused person had made a report at Langata police station to the effect that he had been involved in a shooting incident. And so the team that was investigating the murder case got an interest in that shooting incident report, and eventually a team from the homicide department, the Directorate of Criminal Investigation, took over the investigations of both the shooting and the murder incident. The investigations in this matter were led by PW 35 Chief Inspector Otieno. It was the evidence of Chief Inspector Otieno that in the course of investigating the shooting incident, they discovered that there were contradictory statements as to how the shooting occurred. With that as it were, back to the murder issue. The first accused person was arrested, subjected to an identification parade. It is the evidence of the prosecution that he was identified by 3 witnesses. Subsequently, the second accused person was also arrested. And according to the prosecution case, she was arrested because, 1, she was within the vicinity of the commission of the murder. According to the prosecution, the vehicle that was used in the commission of this offense was hers. According to the prosecution, she aided and abetted the first accused person by providing that vehicle. According to the prosecution evidence, she switched off her phone at the time when the offense was being committed. According to the prosecution case, she gave false information to the police about the shooting incident, and the intention was to divert their attention from investigating the murder charge. And finally, according to the police, she aided and abetted and or was aware of destruction of the evidence that will be used in the murder case through the burning of the items that were recovered, believed to have been the items used in the commission of the murder and eventually destroyed. In a nutshell, that was the prosecution case. At the close of the prosecution case, each accused person was placed on their defense after the court found they had a case to answer. The first accused person gave a sworn statement in his defense and testified to the fact that he works as a security consultant, and that on the 19th day of September 2018, he dropped the second accused person at work at 8:05 a.m. and returned home at Royal Park Estate in Langata. It was his evidence that he stayed at home until about 3 o'clock when their house help notified him that there were people from Kenya Power and Lighting who had gone to attend to an issue at the house. And so he went to attend to them, and that was done. It is his evidence that he eventually, excuse me, that he left the house at 4:30 p.m. to a place known as Roadhouse along Dennis Street Road, where he arrived at 5 p.m. He met a friend by the name of Jennings, who testified as prosecution witness number 8. According to him, after their conversation, they went looking for fuel for his vehicle, got fuel. He dropped Jennings back to pick his vehicle from where he had left, and he, the first accused person, proceeded to join the second accused person at a club in Westlands described as Club 4040. It is his evidence that they left the club at 4 a.m., drove home and slept. That the following day, which was the 20th day of September 2018, he dropped the second accused person at work and then went to pick her at 8 p.m. After and before they left, a quarrel ensued between them, which spilled to home. And when they got home, the second accused person threw his things out of the house. And as he was extremely drunk, he didn't realize that he had a gun. His gun went off and injured him. That the gun was not his. It belonged to his neighbor by the name of Brian Kasaine Spira, PW17. And so he rushed to Brian's house and told Brian to go and secure the gun. Brian went secured the gun and assisted him to go for treatment. He was taken to Langata Hospital. Langata Hospital referred him to Nairobi West, and eventually he ended up at Kijabe AIC Hospital for admission and treatment. That he was later arrested, taken to his residence. A search conducted, several items picked up, and he was charged. In a nutshell, that was his evidence. As already indicated, the second accused person gave evidence through an unsworn statement. Her evidence was that on 19th day of September, she went to work as usual, worked until about 8 p.m., and as she was leaving work, she was requested to stay on as there was an interview for the former governor of Nairobi County, Mr. Mike Sonko. She agreed to do that. She stayed there. After the interview ended, she joined others. They went to Q Lounge and eventually ended up at Club 4040 at Westlands. That they were joined by the first accused person slightly after midnight, stayed there until 4 a.m. and went home. And that the following day she went to work as usual, and that when she read the news item on the deceased's death, she did so in the ordinary course of her business as a newscaster. And so generally she denied knowledge of the commission of the offense. She denied knowledge of the deceased. She testified she had no motive to kill the deceased and that she was not there, basically advancing the defense of alibi, and invited the court to take and used the statement of PW11 Chelagat, who had testified that they were together in Westlands. Just to play back as one of the testimony and evidence of the first accused person, it was his evidence that he did not know the deceased at all. So that ends a summary of my factual background. Okay, I'm on page 15. Please drink adequate water. I'll probably go to page 115. I'm now taking up the analysis and determination. May I, for the benefit of the councils, because I think we all come to court to give the court evidence and would really want to appreciate that the court analyzed all the evidence. I can assure you I did. I can actually read this judgment for 6 hours without a paper in my hands. Okay. So why am I telling you this? If you do not hear me read out your submissions verbatim, please wait for my judgment. I have, as a general statement, taken into account your submissions. In my understanding at this point, the key question to determine is whether the prosecution has discharged its burden of proof, which is beyond reasonable doubt that each or both accused person murdered the deceased. It is tried law in criminal cases that the burden of proving a crime lies on the prosecution to prove the ingredients of the charge beyond reasonable doubt. This is explicitly set forth in the provisions of Section 107, 108, and 109 of the Evidence Act, which is Cap 80 of our laws of the land. These provisions of law speak to proof of the existence or otherwise of a particular fact in relation to the offense under consideration. The burden remains on the prosecution throughout the trial. The rationale behind the proof of the prosecution case beyond reasonable doubt is based on provisions of Article 50, Sub-Article 2 of the Constitution of Kenya 2020, which stipulates that each person has a right to a fair trial, which includes the right to be presumed innocent until the contrary is proved. There is ample judicial authority underscoring this principle of burden of proof. I'll draw your attention to two cases that are made reference to. A case from the Supreme Court of Nigeria, Bakare versus State, and I'll just read a bit of what the court said in that matter, that proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversarial system of criminal justice. To displace the presumption, the evidence of the prosecution must prove beyond reasonable doubt that the accused person is guilty of the offense charged. Absolute certainty, however, and please carry with you these words, they may be important later. Absolute certainty is impossible in any human adventure, including administration of justice. Proof beyond reasonable doubt means just what it says, but does admit a high degree of consistency with an equally high degree of probability. Allow me again to draw your attention to the case of United States versus Smith. Long citation, you can pick it. Long quotation from that case, but very important. And this is what the court had to say. The burden is upon the state to prove beyond reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome doubt concerning the defendant's guilt, but it does not mean the defendant's guilt must be proved beyond all reasonable doubt. A reasonable doubt is a fair, actual, logical doubt based upon reason and common sense. A reasonable doubt may be either from the evidence or lack of it. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime by evidence that firmly convinces each of you and leaves no doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find there is reasonable doubt that the defendant committed the crime, you must give the defendant the benefit of doubt and find that the defendant is not guilty under the circumstances. Moses Nato Raphael versus Republic. Rain states an important point. Burden of proof lies on the prosecution. But does not takes note of exceptions. A few instances the law may shift the burden to an accused person. And they quote a celebrated case of Wilmington, which is cited under 1935. Allow me to take a bit of time on these authorities because I'm sure the lawyers understand the importance. It does recognize that although the burden of proof is on the prosecution, as we put it in our world, by every general rule there is an exception. And so, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, subject to the qualification involving the defense of insanity and to any statutory exceptions. If at the end of the whole of the case there is reasonable doubt created by evidence, as I've already said, the doubt goes to the benefit of the accused. May I again just draw your attention to Nyanjui versus Republic. I am now back home. I've been to Nigeria and UK. I've come back home. Criminal Appeal number 96 of 2021. But that quotes our otherwise well-known jurisprudence guru, Lord Denning. Miller versus Ministry of Pension, 1947, All England's Law Reports. What did Lord Denning say? That a degree is well settled. It not reach certainty, but it must carry a high degree of probability. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. I'll read that again. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the cause of justice. If the evidence is so strong against a man as to leave only one remote possibility in his favor, it is possible, but not in the least probable, the case is proved beyond reasonable doubt, but nothing short of that will suffice. I have said enough on reasonable doubt. Having said what I have said and set the law as it is, I shall now turn to the charge before this court. It is a charge of murder. Section 203 is read together with Section 204. The pertinent section is 203. I quote it. Any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. The above ingredients of the offense have been settled. The elements, the ingredients of the offense of murder have been settled through various court decisions. I have picked a court of appeal decision that sums up the ingredients of the offense of murder. Joseph Githua and Njuguna versus Republic, 2016 EKLR. And this is what the court had to say. Under Section 203 of the Penal Code, any person who of malice aforethought causes death of another by unlawful act is guilty of murder. It is clear from this section that the prosecution must prove beyond reasonable doubt to secure conviction of the offense the following. 1. The death of the deceased. It's important we take note of this. My judgment dwells on these ingredients. The death of the deceased. 2. The cause of that death. And for ease of understanding, in my judgment, I've discussed the death of the deceased and the cause thereof together. The second ingredient is that the appellant committed the unlawful act which caused the death of the deceased. And finally, that the appellant had harbored malice aforethought. So based on the provisions of Section 203 and the authority I've cited, I have drawn the ingredients of the offense of murder as follows. You must prove the occurrence and the cause of death. There's need to prove that death was lawful or unlawful. Most likely for the prosecution, they'll be saying it was unlawful. There is need to prove the offense was committed by the accused person. And finally, the prosecution needs to prove malice aforethought. So right away, I move to the first ingredients, the death of the deceased. It is the prosecution case the death occurred. And to prove the death occurred, the prosecution, through the evidence of PW13, that is the caretaker, the evidence of Stephen Wanjohi, P14, and the evidence of George Kimani, P11, is to the effect that they were the first persons on the morning of 20th of September to go to the deceased apartment and found her body in the bathtub. We are answering, did the death occur? Secondly, we have the evidence of PW2, the scene of crime officer, produced photographs number 27 to 42, showing, among other things, the body of the deceased in the bathtub and after it was removed from the bathtub. Thirdly, we have witnesses who identified this body at the Chiromo mortuary for purposes of postmortem. They included the deceased brother, PW10, the uncle Peter Njenga, Sergeant Maina, and Police Constable Biko, both from Kilimani Police Station. And finally, we have the doctor who performed post-mortem, Dr. Njenga, Peter. He confirmed, he carried and performed post-mortem on the body of the deceased on 24th of September 2018 at Chiromo Mortuary. So from that evidence, it is the finding of this court that the prosecution have proved beyond reasonable doubt the first ingredients of the offense of murder, that the death of the deceased occurred. It suffices to know the defense did not dispute the occurrence of the death of the deceased. I now move to the cause of death. May I draw us to the provisions of Section 213 of the Penal Code, which is very long and which I've made a general reference to. And so it provides the circumstances under which the cause of death may be inferred and proved by way of circumstantial or medical evidence. And in that regard, allow me to draw your attention to the case of Benson Gunyi versus Republic and request that you look at it later. In support of the prosecution case as to what caused the death of the deceased, the prosecution called the doctor who performed a post-mortem on the body of the deceased. And this is what the doctor said, that he made an observation. It was a body of a female aged about 28 years. It was wrapped in a blood-stained wet maroon and white bed cover. Both hands and right leg had henna tattoos and sealing straps. On examining the body externally, he noted that there was an irregular, invasive wound, interior neck, measuring 7 by 6 centimeters, with visibly slit trachea and airway. That there was blood oozing from the nostrils. The body was pale, an indication it was lacking blood. He saw contusions on both wrists and bruises around the wrist of both legs. Internal examination revealed that the airway had been shot through and through. The trachea had been transected at the level of thyroid glands, and the right carotid artery on the neck and right jugular vein had been severed. The doctor says that means cut through and through, and there was blood oozing from her private parts. So the doctor formed the opinion that the cause of death was exsanguination due to severe neck injury due to sharp force trauma, and that the probable weapon used was a sharp object. So based on this evidence of the doctor, it is the finding of this court that the prosecution have proved that the cause of death of the deceased. Okay. The third element I am addressing is whether that death was lawful or unlawful. Article 26, sub-article 3 of the Constitution of Kenya states that, excuse me, a person shall not be deprived of life intentionally except to the extent authorized by the Constitution or the written law. We all know that if a death sentence is applicable and the court makes an order that you go and suffer death, yes, you are entitled to your life, but once the court makes a finding, then you fall under this provision as an exception. So the question one would be asking is, now that we have established the death occurred, and what caused it, then was that death lawful? In addition to, say, Article 26, may I draw your attention to the case of Gusambizi Wesonga versus Republic 1948, where the court said this: every homicide is presumed to be unlawful except where circumstances make it excusable or where it has been authorized by the law. For homicide to be excusable, it must have been caused and testify to any circumstances that would amount to excusable homicide. In cross-examination of the doctor by the defense counsel, he stated that there was no evidence of strangulation, nor a gun or bullet wound, and there was nothing unusual in the pancreas, indicating that the blood that was oozing from the nostrils was because the throat was slit at the level of the thyroid glands, and ratified that the wound would not have been inflicted after the death, because a person does not bleed after death, as it is the heart that causes the bleeding. Pursuant to the evidence of this doctor, it is the finding of this court that the deceased did not die of an accidental or natural cause. The death was not accidental, it was not an unnatural death. Therefore, this is a clear case of homicide that falls outside the excusable homicides. And so, the finding of this court that the prosecution have proved that the death was unlawful. We are still on our ingredients of the charge. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now I'm analyzing the evidence the prosecution have adduced in answer to the question as to whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just mention some of the items that fall under this. There is the issue of identification parade. There is the issue of the clothes which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner, again for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nanda treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages, or 35 pages, is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to move. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following, that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth chained into those cloths, went to the deceased house, committed the murder, chained out of those cloths, and does it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that the first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Harun entered the deceased house and left. And that saying those contradictions arise from the record held by the protected witness number 3, the guard at the gate, that shows that Harun entered the deceased house at 23:21 and left at 23:31. And therefore, that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? They have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Janice, that the first accused person had a bag in which he carried a white counsel when all other witnesses do not speak to a bag. They have invited this court to consider that the accused person has said he didn't know the deceased, and therefore there is no way he would have even known that he was coming from South Sudan. They have told this court to consider that when you look at the ID card of Becerra and you look at the accused person, there is no relationship. They have invited this court to take cognizance. May I request that you probably stop there for now? Thank you very much. I realize that I need the attention of the council, but they need water, so I hope you have water.
Thank you.
This court has been invited by the first accused person in his submissions to take note of the fact that there is a message that was sent to PW16 Kaka from the phone of the deceased person saying, "Kuja unisaidie kulala." And that if that message got to the deceased Sudanese boyfriend, he would have gotten infuriated, he would have gotten annoyed, and probably would commit the murder. This court has been invited to consider that the forensic evidence showed that other than whatever evidence the prosecution had brought, there were 2 other unknown male whose DNA was found on the strappings that were used to tie the deceased. And so the argument by the first accused person is that it is these 2 other male persons, they are known, that must have committed the crime. This court, I said the first defendants treated me to quite lengthy submissions, and I took all of them into consideration. This court has been invited to note that the allegations by Brian Kasaine Spira that he was called by the first accused person at 2 a.m., asked for paraffin to go and burn some items, is not true. This court has been invited by the first accused person to find that the shot that the prosecution produced in this court, having blood stains of the deceased and which has been attributed and said to belong to the first accused person, is not the shot which the police collected from the first accused house. That if the prosecution needed to prove beyond reasonable doubt that shot is the same shot they collected, they should have brought a photograph thereof. This court has been invited by the first accused person to make a finding that the identification process was flawed. This court has been invited by the first accused person to find that there was an intention by the investigators to fix the first accused person, and that is evidenced by capture of a wrong vehicle somewhere in Karioko to tie the evidence of a witness who said that the first accused person told him he stays in Italy. This court has been invited by the first accused person to make a finding that the evidence by Jennings PW8 that he drove the second accused person's vehicle is a lie, and that he had his own vehicle and at no time did he drive the second accused person's vehicle that was with the first accused. The court has been invited to make a finding that there was no blood stain at all on the shot that the deceased had, and which was, the first accused had, and which was collected from his house. The court has been invited to consider that the investigating officer did not investigate satisfactorily or adequately whether the deceased Sudanese boyfriend was in Kenya and could be a suspect. The court has been invited to note that other persons who were in the deceased house on the material night were never subjected to an identification parade. And so, in a nutshell, the court is being invited to make a finding that the prosecution have not discharged their burden of proving the case against the first accused person beyond reasonable doubt, and he should be given the benefit thereof. That this court do dismiss the case against him for lack of merit. So, having considered the evidence that I've spoken to and the submissions, I've raised the following issues for determination. 1, whether the first accused person knew the deceased prior to her death. Secondly, whether the first accused person stole and used the stolen identity card to access the Moria Gardens where the deceased was staying. Thirdly, whether the clothes that the first accused person was wearing on 19th of September 2018 implicates him in the commission of the offense. Fourth, whether the accused person was in the deceased house on 19th of September 2018, and whether he was the last person to be seen with the deceased. The fifth item, question. Whether the first accused person had a gun on the particular night and used it to subdue the deceased. The next issue I'll be looking at is whether the first accused person was positively identified on the identification parade. And Lastly, but of course not the least but very important, a recap of whether then the prosecution have given this court adequate evidence to make a finding that the first accused murdered the deceased. So let's take the first issue. And the question is, did the first accused person know the deceased prior to her death? And this question has arisen because the evidence of the first accused person is, I did not know the deceased at all prior to her death. So let's analyze the evidence together. I have considered the prosecution evidence and the evidence of PW10, George Kimani, the brother of the deceased, is that he is known to the accused person because they were together at Kenya Polytechnic. As far back as, I think, 2002, they were in the same class, taking the same course in hotel and beverage management. It is the evidence of that witness, please mark the date, on 31st of August 2018, he was with the first accused person in the house of the deceased. The death hearing was on allegedly unknown time, but it's said to be 19th of September. But I am saying, and I said, please mark the date. This witness, the brother of the deceased, says, prior to the death of my sister, on 31st of August 2018, I, my girlfriend, the first accused, and the deceased were in the deceased's house. Ramuria Gardens, same apartment. And that the sister, the deceased, mentioned to him that she was communicating with the first accused on Instagram. That on the material night, the first accused person and him slept on the sofa set, otherwise known as the couch, whereas the deceased and the brother's girlfriend slept. And I'm not saying this for no reason. Everything I say has a reason. Slept on the deceased bed. It is also the evidence of George Kimani. On 19th of September, the deceased sent him a screenshot of a conversation between her and the first accused. And that conversation was to this effect. The first accused was telling the deceased that when he returns from Mombasa, he would go and see George Kimani, that is the deceased brother, for a drink. And that the deceased was telling the first accused person, don't spoil my brother. 19th of September. My observation from the evidence is that this evidence of George Kimani, that on 31st of August 2018, he was in the deceased house with the first accused person, was not disputed through cross-examination of the witness by the first accused person. And I will tell you why. This was the nature of cross-examination by the first accused person. I quote, "The deceased was communicating with Joey, but she didn't describe how they were. I believe they were friends. There is a night we spent with the first accused in the house of the deceased. We were all happy. I slept on the couch. I woke up in the morning. The first accused person had already gone. When I woke up, I was not very drunk. I wouldn't know what the first accused person did with my sister when I was asleep. I don't know whether he was another man in my sister's life. If he was, I would have known. I did not know Kako. And my analysis of this cross-examination does not lead to an accused person denying that I don't know the deceased. Further to this evidence, it is the prosecution case that there was a video retrieved from the first accused's cell phone, which was allegedly recorded by the first accused person, which shows that he was in the deceased house prior to her death. I did not have the benefit of that video. I must make it clear. But more importantly, and this evidence to the court was very important. Why am I saying it was very important? Because the evidence of George Kimani is evidence from a relative of the deceased. I treated the next evidence that I'm going to speak to as independent evidence to the question as to whether the first accused person knew the deceased prior to her death. This is the evidence of number 70110, Corporal Jonathan Limo, who testified as PW33. This is an officer tied to Safaricom law enforcement. He's a data analyst, and he said in his evidence that he analyzed data from a telephone number 0727 001675 registered in the name of the first accused person, Joseph Irungu Kuria. He also analyzed data from two cell phone numbers, 0727, 0704 170422, 0715 775856. Both of them were registered in the name of the deceased, Monica Kimani. It is the evidence of this witness that on 1st of September 2018, the number of the first accused person called the number of the deceased. And that call was made at DOD Langata, and it was an outgoing call. Based, therefore, on the evidence of George Kimani and the data analyst PW3, it is the finding of this court that the evidence by the first accused person that he did not know the deceased prior to her death is untenable, it is insincere, and it is an afterthought, and it is false. It is the finding of this court that the first accused person was known to the deceased prior to her death. Allow me to move to the next item. This next item is whether the first accused person stole an identity card of Dominic Bisera and used it to access Ramuria Gardens, where the murder took place, on the fateful night. I will be probably returning back to this evidence. You will get to know why, but let me speak to it now. Excuse me. Dominic Bisera Harun testified in this court. And his evidence was to the effect that on 17th of September 2018, he went to Royal Park Estate in Langata to look for casual work. The requirement at the main gate was that you leave your identity card at the gate. And so he left his ID card at the gate. And he was supposed to collect it in the evening, after work. When he came to collect his ID card, he did not find it. The following day he went, he did not find his ID card. I am speaking to the events of 17th September 2018. And so, he left his contacts written in the book with the guards, the occurrence book, contacts, Dominic, telephone number, and said, turn into a bit of Kiswahili, mukipata hii kipande changu, tafadhali mnijulishe. I have had the benefit of that record. It is his evidence that he never got his ID at all. I have had the evidence of the witness who came from the Registrar of Persons who has confirmed to this court that Dominic Bisera Haron eventually got a duplicate ID in the year 2019. There is evidence from witnesses at Royal Park that is true, Dominic lost his ID. There is evidence from Protected Witness 3A to the fact that the person who went to the deceased house on 19th of September 2018 produced an ID in the name of Dominic Bisera Haron. This witness identifies the first accused person on the parade as the Dominic Bisera Haron. I'll come to the parade. And so, at this stage, I find adequate evidence that the ID of Dominic Bisera Haron was stolen at Royal Park Estate in Langata on 17th of September, 2 days before 19th of September, when the offense was committed. I have made an observation that this ID was stolen from Royal Park Estate Langata, and it happens that the two accused persons were residing at Royal Estate Langata. As to whether the first accused person used this ID to access the Muria Gardens and commit a murder, hold it. The next question and issue I'm going to address is whether the cloth which the first accused person was wearing on the material date implicates him in the offense. I have taken a route of flow from where he started. And of course, we all start by dressing in our houses. Hopefully. I'm not saying anything. So the first evidence as to the cloth which the first accused person wore was the evidence of Pamela, the house help, PW 15. She says that when the first accused person left the house on the 19th of September 2018, he was wearing a white shirt with patterns, a maroon cap or cap, and brown shorts. Now, the prosecution produced a brown shirt marked as exhibit number 9 and a maroon cap marked as prosecution exhibit number 4. And they were shown to the witness, and she says, yes, they look like what he was wearing. And then she's cross-examined by the first accused defense counsel and picked an extract from her answer in cross-examination, and this is what she said. Joey left at 4 p.m. in brown short, maroon cap, and a small bag. This is not in my statement. This shot is the one produced in court. End of quote. So that's Pamela. What the first accused person was wearing when he left the house. When the first accused person left the house, the next person he met was a gentleman known as Jennings, who was given evidence as prosecution witness number 8. Let's see what Jennings said about the cloth. Jennings confirms that he met the first accused person at Rose's house, and in relation to the cloth he was wearing, he says this. The first accused person was wearing a t-shirt, a maroon cap, and a brown short. Again, he's shown exhibit number 9. He says, yes, this short looks like what he was wearing. And he's shown exhibit number 4, and he says, this cap looks like what he was wearing. Jennings goes beyond these 3 items, the t-shirt, the short, and the cap, and says this, that he left Roadhouse where he was meeting with the first accused person, and that the first accused person requested him to drive his car, and of course then he went to the passenger seat. He took a bag which he had. He removed a white kanzu from the bag and a 4th item or cloth, white kanzu, and put on top of his cloth. And then he left to go where he was going. So the second person who speaks to the cloth which the first accused person was wearing is Jennings. And he speaks to a t-shirt, he speaks to a maroon cap, he speaks to a brown short, and he speaks to a kanzu. The third person who spoke to the cloth which the first accused person was wearing is PW11, Chelagat. Chelagat tells the court that she knew the first accused person because she is a friend to the second accused person. And Chelagat says that on that particular date, the 19th of September, she went to Roadhouse. Remember, Roadhouse is where the first accused person and Jennings were meeting. She went to Roadhouse in the company of her friend called Juju. They found the place was packed, and because she knew the first accused person, she and Juju joined the first accused person and his friend Jennings on their table. They had drinks and food, and when she's asked the clothes the first accused person was wearing, she says the first accused person was wearing white shoes, t-shirt with some prints at the front, a brown khaki short, and a maroon cap. Again, she's shown the white short, the brown short. Exhibit number 9, she says it looks like it. She's shown the cap, she says yes, it looks like it. She is cross-examined, an extract from her evidence I took. She says, I described the short as brownish. There are back pockets. The short had side pockets. At 40-40, he was wearing the same short. The fourth witness who speaks to the clothes the accused was wearing is the guard at Lemuria Gardens. And I'm hoping the manner in which I'm flowing my decision is helping us to move with the movements of the first accused. From the house, road, house, and then allegedly we'll come to see whether it's an allegation or it's been proved. Lemuria Gardens. Now, this witness says this, that the person who came to the deceased house identified himself as Dominic Bisera, Harun, came in a taxi and he was wearing a white kanzu. the next witness who speaks to the cloth which the first accused person was wearing is PW7, Lee Owen. Lee Owen says that when he went to the deceased's house, he found the first accused person was introduced to him as Joe, and he was wearing a pure Muslim white kanzu, ash gray coat, red stroke maroon cap. And he says this: that in fact the deceased person made a comment on the white kanzu which the first accused was wearing. And she said, I've translated it into English but in Kiswahili, kwa nini huyu leo amevaa kanzu? Kwa kawaida huwa havai kanzu. That the deceased remarked, why is the first accused person wearing a kanzu today? He usually does not wear a kanzu. Now, what comes out of the evidence of these witnesses? About 5 of them. 1, that all of them, Pamela who was at the house, Jennings who was at Roadhouse, Chalagat who was at Roadhouse, 3 of them speak to the same 3 items or cloth that the first accused was wearing. T-shirt, brown short, maroon cape. All of them. Then we have the second set of witnesses, but there is a bridge, which I'll bring. Jennings, the guard at Ramura, and Owen speak to a white kanzu. The question is this: why is there divergence? How come Pamela does not speak of a white kanzu? How come Chalaga does not speak of a white kanzu? And the answer was not far from the analysis of the evidence. The answer is, when the first accused person is said to have left the house, he was not dressed in a kanzu. So this kanzu is, according to the evidence of Jennings, was worn just before he went to the house of the deceased. And so anybody who met him before he went to the house of the deceased would not have seen the kanzu. Do these clothes implicate him in the commission of the offense? Hold your horse. Three other things on this cloth. 1, were these clothes recovered? If so, where? The evidence reveals that the short and the maroon cape were recovered and they were produced in this court. The police have brought an inventory that the first accused person is supposed to have signed, acknowledging the clothes were found in the house where he was staying. Those clothes have been shown to the witnesses. They have identified them. But what was not brought to this court was the white kanzu. And how do the prosecution deal with the absence of the white kanzu? They bring evidence to the effect that during their investigations they discovered that there were items which the first accused person burnt. And among those items, they recovered the remnants. There was a white piece of material which they believe was the kanzu that was not completely burnt. The court had the benefit of seeing the white kanzu piece of material. My observation as a court, it was evident that piece of material was stitched. You can see the running of the machine. So it's not like somebody just cut a piece of material and there it was, there were stitches. Which in the logical conclusion is that it must have been a piece of cloth stitched for wearing. 2, and I'm now getting into the submissions that were brought and by the parties. The first accused persons heavily submits on the fact that the shot which has been produced in this court as prosecution exhibit 9 was not the shot collected from his house. And you will understand why that evidence is heavily fought, because that shot is supposed to be having blood stains of the deceased, critical. But the evidence is this, that shot, when it was recovered, it was entered in an inventory, and the accused signed the inventory. The argument of the first accused person is that this shot in this court is faded yellowish. I had the benefit of seeing that shot. There is nothing faded yellowish. It is a khaki brown shot. This court was told khaki is not a color. It is a mixture of nylon and others. The color is not khaki, the color is brown. I had the benefit of looking at that white piece. It's a relatively big piece, and one cannot rule out that it may and was the counsel. But I did also take cognizance of one important thing which none of the parties here submitted to, but I am expected as a judge, as a court, to comb through all the evidence. And I did. There was a lot of contestation on the shot, but it was very clear. No one disputed that the first accused person is supposed and was wearing a maroon cap. So a lot of questions was on white counsel, and the brown shot. No question on the maroon cap. Yet, this maroon cap knits and joins right from the house where the first accused left. The house help says he wore a maroon cap. Jenny's at Roadhouse, he wore a maroon cap. You go to Chelagat, he had a maroon cap. You go to the guard at Ramuria, Haron had a maroon cap. You go to the witnesses who are in that house, he had a maroon cap. A maroon cap has been produced in this court. Does the accused person say it's not mine? No evidence to that effect. I have also considered the submissions by the first accused counsel that the clothes that have been brought to this court are generally ordinary clothes that you can't get in the market, and that they did not have any specific identifiable marks that would pin the first accused. And my simple argument is this. Really, when clothes are manufactured in the factory, they manufacture them in bulk. The only way I will distinguish the other day I saw a newscaster wearing I will not tell you who, a blouse like mine. And I'm sure any one of us can speak to the fact that we wear clothes that are manufactured in the same place, isn't it? The only difference is the size. So if you want to say that my clothes have an identifiable mark, then I should put that mark for that purpose. Otherwise, clothes are just clothes. So the fact that this cloth did not have any marks that would say this cloth only belonged to so and so, for me was not a tenable argument. But my findings on that is that there is corroborative evidence as to the cloth which the first accused person was wearing on the material date. Please allow me to move to the next issue. In that reading, I've done away with quite a bit of material, so you will not wait for too long. Summarized quite a bit of it. And so the next question is whether the accused was was in the first accused was in the deceased house on the material date, and whether he was the last person to be seen with the deceased. Now, considering the evidence of PW7, Lee Owen, his evidence is that the first accused person was in the deceased house. Waridi did not testify, and nothing much can follow on his evidence if he has not been tested on it. But the strongest argument the accused person is advancing is that, look, there were these two other male persons. First of all, there were other people that